All right, guys, we're going to go ahead and get started. My name is Richie Kidwell. I'm the president of the Restoration Association of Florida. I want to thank you guys for coming to this event. We're going to have a lot of good information coming to you here over the next 2 hours. Feel free to take notes inside of there. That is yours to take home. Within there is that PowerPoint presentation that we're going to go over. John Tolley, our sponsor today with JT Law Firm, is going to speak on the second hour. So I'll introduce him right before he goes up. A part of our association here at the Restoration Association of Florida is not only the networking part of it, to create a single united front on the restoration side for years and years since I've been involved since 2014, and just when I created this association. So we've had the years of we didn't have to sign an assignment of benefits or have a set way that we had a contract here. In 2019, mandated that we did. We had certain portions of the contract that we had to ensure there was a hold harmless clause for the insured. It was turned in within 3 days. You had a line item detailed estimate along with your assignment. And we learned over the years that the laws have changed in the courts. It made us update our contracts a little bit differently, and when they had to be signed both by the contractor and by the assignee and turned into the insurance company. So we've lived through those types to keep our independence here in the state of Florida as independent contractors. So I've been an advocate for independent contractors now since I got in the game. I love this industry, and it's something that I wanted to continue to advocate for. So we brought in lobbying teams. And through our lobbyists and by talking with minority presidents there, we were able to hold some very meaningful conferences there in the state of Florida, where at this day, we brought up over 100 contractors all wearing these yellow t-shirts. AOBs protect homeowners. And what we saw up there was opposition. They were wearing red, and they were talking about AOB contractors, how they run away with all the rights of consumers. They were talking about how roofers, because they got an AOB, would jump up on the roof and create damage, all because of the assignment of benefits. I heard it all, and that's what the folks in Tallahassee were hearing. So we created this unified front, this unified voice to tell them, say, no, that's not the case. We do help consumers. Without us, how can somebody that doesn't have the money to put their home back to pre-loss condition, how can they do that without service providers like us? I'm still curious on how they're going to do it now that AOBs are becoming invalid on all policies born in 2023. So today, you can still use an assignment of benefit on any policy that was born in 2022. You don't have attorney's fees on them because any instrument signed from any assignment of benefit instrument that's signed on May 26th or forward of last year doesn't have attorney's fees. So even my company alone, I have to bring in in-house counsel to file suit for $2,000 or $3,000 against the insurance company so I can collect my money because my bills are small. So we've all had to make a lot of changes, and some have already went to the direction of pay. We're going to talk about that. That'll be towards the end of my presentation. And then Attorney John Tolley is going to talk about his portion on the way that he's strategizing business owners to collect their money against the insurance company. All right, so with that said, we'll get on with it. Anybody that bought a policy in December 15th of 2022 has what we call the gold policy, the one that'll last them all the way through storm season with prevailing party attorney's fees for homeowners. And you'll see other changes there. Remember, the effective date is policies that were born or purchased, so either purchased or renewed after these effective dates, and then a claim happens, right? Because Hurricane Ian was in September. Right? Nicole was, I think, a month later. All that before December when all the law changes became effective. That's when the governor signed the bill. So there'll be some effective dates that I want to go over to make sure you guys have a good understanding. And when does it change to where the Office of Insurance Regulation or the insurance companies have 60 days to pay a claim or give notice of denial? And I'll give you all that information coming up here, so we'll kind of go through it. So here's the recap of the 2022 special session. Is what we're going to go over. Civil Remedies Bill, House Bill 837. That was signed into law March 24th of this year. So we had some changes that the insurance companies have to do in March and then also in July. So we'll talk about that. The public adjuster bills, most people didn't realize that there was a major public adjuster bill going through. 2 of them went through. One of them was really nothing. It was Senate Bill 1158 was nothing. It was more of like a change of power within the departments there. But Senate Bill 1398 is a public adjuster bill that made significant changes for public adjusters. It did not change their percentage, which was going around for a while that said that they were going to try to limit their percentages. They didn't touch that. It's more about cancellations, time periods, and when they're going to turn in their estimates to the insurance company and to their insured. And then, of course, the insurance accountability bill, that was the, whoops, we screwed up and we came out too strong, so let's try to fix this. And so they made a couple of fixes in there for consumer protections. So we'll talk about that. All right, so the major changes to know about and when they would become effective. We had a FORA program, a Florida Optional Reinsurance Assistance Program. That was optional for insurers. They, every year before June, they have to have their reinsurance updated. Fun fact, the real reason why insurance rates continue to rise because the ever rising cost of reinsurance. Right, I think USA Today article came out last week, and they said the top 3 reasons why insurance rates are going up in the state of Florida, they called climate change, they said inflation, and they said reinsurance. Not one time did anybody make mention of roofers, contractors, attorneys, claim volume, none of that BS. All right, so prompt pay laws for property insurance reduces the time for an insurer from 90 days to 60 days to pay or deny a claim. Now remember I said that. Now they reduced it from 60 days to pay or deny. The next line though, OIR can extend for another 30 days for any reason. So I would not get used to saying they have 60 days to pay. I still say they still have 90 days. Because OIR, let's be honest, they will allow any insurance company to do whatever they want. And we've seen that from their rate increases and crazy policy endorsements. All right, so reduces the time for insurers to review and acknowledge a claim from 14 days to 7 days. That's a little bit better. They have 7 days to acknowledge your claim now instead of 14. Reduces the time from 14 days to 7 days to begin an investigation, and reduces time from 45 days to 30 days to conduct a physical investigation and applies to hurricane claims. Requires an insurer to send adjuster's report in 7 days, effective March 1st on 2023. Right, and so they're already saying, no, Hurricane Ian and some of these other claims or whatever, if it's not filed after that date, they don't want to send you the adjuster's report. Good stuff. All right, so awards of attorney's fees in litigation under property insurance contracts. It removes the right to attain prevailing party attorney's fees from a residential or commercial property insurance policy. So, and it reinstates the application of the civil offer of judgment, PFS. So that means that it allows, in my interpretation, my non-lawyer interpretation of this is that, because I've heard it from both sides, it opens up the ability for either side to PFS the other, proposal for settlement. Some attorneys look at it and said, actually, it closes the door to both sides. Nobody can do it. And so we're still wondering how that's going to look like when we come into more hearings and more decisions are being made. And I think John will talk about this here later today. Now, this is effective on all policies purchased or renewed after December 16th, 2022. And then a claim happens, right? So here's a little shortcut. Here's the way I do it. If you have a date of loss that comes in, it comes to your company and it says 2023 and the date of loss, immediately you want to get the deck page. You want to see when the policy was purchased, right? If the policy was purchased in 2022, look a little bit further. Was it purchased before December 16th? If so, you have a lot more rights and privileges than you thought you did when you saw a 2023 date of loss come in, all right? So don't get tripped up on the date of loss, get tripped up on the inception date of the policy. So the question goes to service providers. Can we look at the policy to determine what type of contract we want to use? Absolutely. I do it every day. Every day. We're offering to the homeowner, and we've signed probably 600 AOBs last month. We do about 800 a month. It's been a little bit slow. So we're signing that many AOBs, but we're giving that opportunity every time. We look at the data loss. We're doing a lot of Ian claims still too. So that's easy. September 28th, blah, blah, blah. So But now we know for 2023 and we have a policy here, I can still offer the AOB. If not, I'm offering the service authorization direction to pay, 90-day net terms with a letter of protection. And we'll talk about that. It's a different way to contract now that we're being limited on what we can offer contract-wise to our consumers. Assignment of benefit prohibition, effective on all policies purchased in 2023. It could be on January 1st. If you bought a policy on January 1st, 2023, the ability to assign your post-loss assignment of benefits is gone. So if you bought a policy in 2023, you cannot have a service provider sign an AOB under your policy after a loss has occurred. All right? It prohibits the assignment and all policies renewed after the first of the year. Bad faith failure to settle actions against property insurers, effective on or after December 16th, 2022. Arbitration, it allows all insurance carriers to offer a policy that has mandatory binding arbitration clause where each party bears their own fees and costs. It must be sold at a discount. And that's effective on December 16th, 2022. They say, hey, listen, here, I have some cost savings for you right here. And you find out that the discount is like $25, $50. It's really not that much. Like Edison policies are the same. They offer you a small discount if you agree to use their managed care program. So, or Citizens policy, they'll limit you to $10,000 unless you use their preferred pretenders, right? So that type of policy stuff is what is aggravating here in the state of Florida. So, and we're trying to be the watchdogs for that. We're trying to ensure that they don't just roll on over on all of us here. All right, so the first bill that was signed into law in our legislative session here of 2023 was House Bill 837. Amazingly, it went through the Florida legislature in days. It was in the first, the Senate version was in the Banking and Insurance Committee the first week that the session opened. I was there, able to speak in front, but it was already baked. Not only did they reach in and, like I said, take away prevailing party attorney's fees on that day, but in March, they took it a step further, and I'm gonna, and they said, I'm gonna take away attorney's fees on every type of insurance dispute along the way. Auto, medical, life insurance, it doesn't matter. If you have a dispute against your insurance company after March 24th of this year, and again, it could be auto, it could be medical, it could be life insurance. Again, and not just property. So all that stuff came out in March. It modifies the bad faith framework, gives them more time, clarifies negligence alone is not enough to demonstrate bad faith. It provides that a contingency fee multiplier for an attorney fee award is appropriate only in a rare and exceptional circumstance, adopting the federal standard. One-way attorney's fees provision for insurance cases apply in limited situations. It adds a lot more to this, to where we cannot collect from the insurance company as easily as we did before. Emboldening them to slow pay you or deny you unfairly. Now with this new law change, what are we going over to? What's our communication now to the homeowner, right? And so I want to go over that with you. I think it's important to know. With AOBs becoming invalid and all claims on policies purchased on or after January 1st, the direction pay agreements with 90-day net terms becomes a new contract used by service providers. It's a 90-day net terms. And again, I explained the reasons why I'm still saying 90 days. Lien laws, 90 days. Insurance companies have 60 days, but then OIR can give another 30 days. For any reason at all. So we're really looking at 90 days. So I put that in the contract too, 90-day net terms, and then I put the lien language right there on the bottom. And they do that because you explain to the homeowner, I say, whoa, I don't want to get a lien on my home. It's okay, it's okay. It also says in here that if you hire an attorney, if we all don't get paid and you hire an attorney, then all that goes away. Then I'll forgo any collection from you, any interest, any lien filed against your property, or any litigation against you for any unpaid portions. That's a lot easier to talk to a homeowner about. So listen, if you're able to, we're going to ensure that we're not going to lien your property, but you have to be ready at day 91, if we all don't get paid, to file suit against your insurance company. And by the way, here's the business card from my favorite attorney. Call them. I work with them all the time. You can absolutely do that. You don't have to do here's 5 attorneys on a sheet, whatever, bullshit. No, we're limited to what we can do now. That allows us to say, hey, listen, I'll forgo your lien or lawsuit against you if you call this guy. I don't care if you call any other attorney, but call this one because I work with them a lot. It's not illegal to do that, all right? All right, so it allows for a deferment of payment if the homeowner hires an attorney, like I said, to pursue payment against their insurer in case of non-payment. A service provider can refer an attorney, it's like I knew what I was going to say, of their choosing to the insured in case of non-payment to the service provider. And again, goes back to that education to the homeowner. It does contain lien language if the payment in full isn't made, and that's what you tell them. We will lien your home or sue you for services performed or without non-payment. And that's our only action. I don't want to, but that's the only things that we have now that the assignment is gone on all policies born in 2023, and then a claim is filed. Again, Hurricane Ian is just fine to still use AOB. All right, so page 2 of the contract is a letter of protection, which instructs the attorney for the insured to pay the service provider when the settlement is made via the settlement funds. All right, and so this is what it looks like. This is just a generic one. We do give them to you at no charge in a Word document, so you can give it to your favorite lawyer and say, hey, review this, make sure it's good, put it on your logo, on your letterhead, and rock and roll with it, right? Your page 1 is your service authorization, direction to pay, net 90-day terms. Page 2 is the letter of protection, and you explain to them, page 1 is for me, so I can bill directly to your insurance company. And page 2 really is the homeowner's protection, right? Because this is what will allow them to settle and defer the payment that's owed to the service provider till the settlement. And that's nice for the folks that can't afford it, don't want to lien on their home, don't want to get sued, because what's the resolve now, right? You file a claim. The insurance company sends out their preferred pretender. They don't pay their own preferred pretender. I know that for a fact. I know some of those guys that don't get paid a lot by the insurance company. What do? They lien the home to make the homeowner scream loud enough to the insurance company until they finally get paid, right? You're putting the homeowner through all that stress, and then you have a 0 rating on Better Business Bureau because you have to lien a home. You know, think about how that's going to look like. I have a 5-star rating because I've never sued a homeowner, right? And I don't want to get into that. So we're trying to figure out best ways to be able to produce or perform for a homeowner and bill the insurance company and give them away in case the insurance company doesn't pay. And this is the way to do it. You have them sign the letter of protection, and you explain to them at day 90, you have to do something. Either stroke me a check, right? Get a lien on your home, or call this attorney. Boom. It's still free for you, right? Because the rest of our service providers are going to ensure that they make sure they have a good estimate. Their exactimate line items, every one, we've talked about the reasons why insurance rates are going up. Well, it's the same way for us. And if you missed it, the 3 top ways that insurance premiums are going up is what USA Today said in an article. They were talking about climate change being one of them. Inflation being another, right? And the rising cost of reinsurance. That's the reason why our rates are so high today in property insurance, right? And so thinking about that, same for us, right? We had a new immigration bill that came through. Our workers are going to cost us more. The cost of products, services, and fuel have gone up. There's no reason why we can't up your line items in every line item and exactimate 20%. There's no reason why you can't put 15 and 15 on overhead and profit. Did anybody say that it all had to be 10 and 10? It can absolutely be 15 and 15. That 30% is what you use to negotiate when you bring it over to the law firm, right? So if the roofer, the mitigation company, the inspector guy, if everybody in there has their prices accordingly to where they can take a 20% haircut at 30% at the end of settlement, then we're all doing right by the homeowner. That means more money goes to the consumer. So just having this knowledge to ensure that you are, a lot of folks are saying, oh, I'm reducing my invoice so I can try to get paid quicker by the insurance companies. That's not the best way to do it. Keep your invoices higher and negotiate on your overhead and profit and your additional cushion on your line items. So this is the portion where I'm gonna switch it over to our sponsor, John Tolley with JT Law Firm. He's one of our sponsors today. And if you're not already a member, please look at our joining our membership. It'll give you opportunities to be able to present like John is doing today. And as well get your name out there on our website in our mail distribution. So I want to thank you for sponsoring the event tonight in the room. Our happy hour is also sponsored by John Tolley and JT Law Firm. So I want to turn it over to John. Thank you so much for the sponsor, man. Woo.
Really excited that you guys are here today. This is obviously a passion of mine. It's one of the reasons why I started the firm is I used to work for insurance carriers. I really couldn't stand how they treated regular people. So what I want to first start with, and the 2 topics that we're going to talk about today is persuasive evidence that you can collect at the beginning, as well as some of the law changes, but not only law changes, some of the orders that Josh and myself have gotten recently that have helped cases get better with your clients, because your clients are our clients, right? You guys have signed them up with contracts. You guys have provided services. The better service we can provide, the happier they are, the happier they are, the happier they are with you guys, right? So I want to first talk about persuasive evidence, because I think that's going to make the case settle quicker, or that's going to make the case go to trial quicker and have a more positive and potentially successful result, right? So let's see here if I walk too far away. So my goal today is talking about persuasive evidence, because most of you people are the first people on the scene, right? I don't get a call from somebody at 3 a.m. saying, hey, water's pouring into my house, right? Nobody thinks about the lawyer first. So because a lot of you guys are the first people on the scene, you can preserve the evidence in a way that nobody else can. The insurance company can't do it. We can't do it. Only you can, right? And so I'm going to break it up into a couple different things, because I think right now, obviously, the hot topic is roof damage, as a result of Hurricane Ian. I think Richie nailed it with the law change. Hey, they might be able to risk it more for the biscuit, right? They might say, well, it's a $50,000 roof claim. I think somebody was saying that lawyers won't even take anything under 80. They might look at it and say, hey, it's $50,000. I'm more than willing to risk a $50,000 verdict against me. I don't have the risk of insurance, attorney's fees. So they might uptick their trial, right? They might uptick the trial output that they want to put out, put less money on the table, which obviously makes an attorney who's tried cases and successfully won cases that much more important. So let's talk a little bit about the wind damage that we see here. I mean, obviously this is very, very obvious damage. When we're talking about tile, we're obviously looking for missing. We're looking for those corner chip, wind chatter, event cracks, and we're looking for lifted and loose. And what I like about pictures like this, I think Orlando, you actually took this photo because I took it from one of our trials, is he's showing you in the photo that it's not connected to the roof anymore, right? He's lifting a ridge cap. It's our highest point. That's where you're going to see the strongest winds. Those types of evidence are going to look a lot better than just general overviews of the roof. So when you go out there, and what I've had some people do on these tile roofs is they actually take like these door stoppers and they start lifting the tile to see if it lifts, right? And you can see how Orlando's just kind of, putting his hand underneath. He's not ripping it up. He's not pulling it with two hands. It's showing that it's not connected and he didn't do anything to mess with it, right? So what they do is they take these door stoppers, and as they go through and they feel the tiles and the tiles are loose, they start putting the door stoppers underneath the tile, obviously not over, exaggerating the lift on the tile. And then you take a step back, and instead of seeing one individual photo like this every single time, now you're going to see 15, 20 tiles lifted. And it's going to look so much more persuasive to the jury because they're not looking at individual photographs of one tile here, one tile here. We're taking a step back and we're looking at all of these tiles on this one slope, all of the tiles on the next slope. And now the jury's looking at it saying, hey, this roof is damaged, right? This isn't something where somebody's just trying to get away with getting a free roof, right? Isn't that the thing that we hear about all the time with these insurance companies is this is a way to get a free roof. That's all this is. The attorneys are trying to get them a free roof. It's all a big scam. Well, if we have evidence like that can show, hey, look, I've got 25 loose tiles here. I've got 15 loose tiles on the other slope. I got another 30 on the back slope, and you can actually see it. It's going to be that much more persuasive, right? So then, obviously, the missing is really easy. I mean, I think in terms of at least Hurricane Ian, we're probably past those type of claims, right? We're probably past the claims where there were tiles all over the ground. We're 8-9 months away. Those people were making claims right away. What we're probably going to run a lot into now is the lifted and loose and the corner chip cracked tiles, right? Because those are the people that are probably going to have roof leaks as this rainy season kicks up. They're going to call you guys and say, hey, I've got a roof leak. You're going to go up there. You're going to see a lot more damage than a regular roof. That would indicate, obviously it was a big event like a hurricane. And then we're going to have to really start documenting this. And this one's a good one because you have multiple corner chip cracks. And, when we're talking about that, we're talking about that wind chatter that goes up and down. Your weakest side is that bottom right corner. Usually when that comes back down, that's what chips, right? And that's what kind of gives evidence of wind chatter. So those are do's in terms of documenting tile. And then with regard to shingle, obviously the far left is super easy, right? I mean, if an insurance company doesn't pay that, they're not going to pay anything, right? But the middle one I think is so important. It might be a little difficult to see from the back, but a lot of time I'll get pictures of creasing, and what will happen is somebody will just run chalk over the crease, and it takes away the effect from the jury, right? They can't see the crease anymore because now they've got yellow chalk over it. What instead is more persuasive is bracketing the creasing and then getting even more close-up photo showing the granular loss in that creasing. Okay, so these are things that I want you guys to keep in mind. I know it might seem basic, but remember, you guys are the first people out there. And what another issue we run into, for instance, is, we had Hurricane Ian, right? And then let's say we have a hurricane this season, but we haven't gotten an expert engineer out there yet, right? So now the insurance company is going to start saying, well, how do you know that damage wasn't present because of Ian or because of the subsequent hurricane that hit in 2023? Because we haven't gotten that person out there. But you guys went out there first. You guys documented the damage. The engineer can look at it and say, well, it's impossible because this person documented the damage right after Hurricane Ian or 3 months before this subsequent hurricane that came. And then lifted, what I really love about these and what I think needs to be shown in more photos, including the tiled roof, we make the argument all the time, right? Hey, repairability. If you're going to go after this one tile, if you're going to go after this one damaged shingle, you're going to have to work your way up the slope, right? Because the roofs are built from the bottom up. In order for you to replace this damaged shingle, you're going to have to take this one up, which takes these two up, which takes these three up, and you're going to have to get up to the ridge, right? Well, the best way to show that is by showing when it's lifted. This guy's got 1, 2, 3 rows based off that one damaged shingle right there. So he's showing you exactly what we're arguing in court. When we go in front of the jury and say, hey, members of the jury, when you have this damaged shingle here, you got to access the fastener. And when you access the fastener, you're going to affect the 2 shingles above it. Well, that's hard for somebody who's not like us, right? You guys are RAF members. You guys do this for a living. I think you said you've been in the business for 25 years. It's easy for us to talk about it. We can go to this happy hour later. We can talk about roofing. We can talk about all of these things. But you have to remember when Josh, Monica, and I are presenting to a jury, these are 6 people who are normal people who most likely don't have experience in our industry because otherwise they'd be off the jury, right? So we're going to have to teach them roofing in about 3 days. We're going to have to teach them roofing from voir dire all the way to closing statement in about 3 days. And so it's better when they can visualize what we're talking about, when we're talking about the lifted shingles causing more damage. And you can see here the person just uses his hand, very, very lightly to show that they're not torquing it up, they're not trying to rip it up, they're not trying to cause any more damage to it, that it's damage that's already present at the property. Don'ts. So this is the problem I get a lot of times. So we'll get a claim that comes in. They had somebody go up on the roof and inspect. And instead of showing all of those lifts like I showed you, we get these chalk marks, right? And I mean, what is that going to do for a jury? It doesn't even, it actually, this one right here makes it look like it's flat and in line. And really what they're trying to show there is lift. And so that's not going to do anything. A jury is going to look at that and say, I don't even know what happened to the roof. It looks pretty nice to me, right? So you've got, you can use these photos, but these can't be your only things in your set. They've got to be more. So for our roofers, contractors, public adjusters, when you're taking those photos, make sure you're not just taking these, but you're supplementing those with those photos, like putting the chalk under the shingle and showing the number of lift, showing your hand and how many rows it's affected. Those are things that are going to help us out. Those are things that are actually probably going to get the case settled quicker. And hopefully it gets it settled with you guys. If it's not able to get it settled with you guys, it comes to us. Their attorney gets on it. We start deposing their corporate rep. They've got to explain how we're not right with the multiple rows that have been affected, how they only allotted for one shingle, and then they want to usually come to the table after that. So let me go. What we're missing a lot of the times is videos. And what I think is underlooked a lot of the times is videos. So for my public adjusters, roofers, contractors, people that are out there right away after an event, right after Hurricane Ian. I mean, you saw this, right? Let's go back. Let's play it again. We'll watch the roof right here. Look at that. It comes up, falls back down, and then it looks pretty good, right? I mean, like after it's done, it doesn't really look like it's that damaged. And this was from a neighbor of one of our clients, right? So one of the things that you can do as a public adjuster, roofer, contractor, somebody who's out there right away, somebody who's tarping the roof, is say, hey, do you have a ring system? Do you have a security system? Were you taking any videos during the hurricane? I know a lot of people like to stand by their window and take videos. Josh actually had a good cross-examination of an engineer in our last trial where he kept telling us the wind wasn't strong enough to damage the tile roof, right? It wasn't strong enough. It was weak winds. So our client had a neighbor who had a ring video. And in the video, a blur goes past the house, past the front door. And so Josh pauses the video and says, hey, what was that? And the engineer goes, I have no idea. It was going too fast. And Josh goes, exactly, it was, wasn't it, right? And jury chuckled. Verdict came back for us for 6 figures, right? So that's what we're talking about is when you're first on the scene, it's, hey, what videos do you have? What alarm systems do you have? What Ring cameras do you have? Hey, I see your neighbor has a Ring camera. Do you mind if I go, are you good friends with them? Have you talked to them? Let's see if they've got anything, right? And then that way, you're building your case from the beginning, and especially for our public adjusters, right? Especially with these attorney's fees being gone, because now you're gonna have to sell the client if the case gets denied or underpaid. Hey, you've got to pay not only my percentage, you got to go pay this attorney a percentage of your claim. So this is going to help you guys enhance your case and make it quicker and better and faster, right? So the videos I think are super important. Let's go into a little bit of hail damage because we have been getting a lot in Central Florida. I know some people here are from Central Florida. So we're looking for bruising. We're looking at Tampa, Orlando, even kind of up by the Villages area has been getting a lot of hail recently. So we're looking for bruising. And what I want to make sure is that people understand that the jury doesn't understand what granular loss is. They don't understand what bruising is. What they need to see is that things are missing on the roof, right? And so the best way to do that, and it's probably difficult to see on this, given the lighting and everything, but what this person did, what I love, is you start out showing the entire shingle, right? Or most of the damaged portion of the shingle. I would start out with the entire shingle, move into this, and by the time you get to this, and you probably can't tell back there or even up in the front a little bit, but you can actually see the matting of the shingle because the person zoomed in so well. So you can see the grains gone off of the roof and you can see the mat. And that's what's gonna help us too with the insurance company, right? Because they're gonna come in and say, well, it's cosmetic. Hail is cosmetic. It doesn't cause any issues with the roof. And our argument is, it's fractured the mat, it's ruined granules, so it's caused the lifetime of the roof to be lowered. That is not just cosmetic damage, that is actually a direct physical loss to the roofing system, okay? So I think a persuasive way is to go at least 3 photos, right? Out, in a little bit more, and then as close as your camera possibly can go to show those grains being gone. All right, what was missing in a lot of hail claims that we've gotten recently? This type of evidence. Now, you're not gonna have 31 hail strikes on a slope every single case, but what we weren't getting is we were getting those individual 1 hail, bruise per shingle, right? And it looks good, but what the jury needs to see at the end of it all is, what does it look like when you back up off that slope? How many hail strikes are on that one slope? Because if I can get up there and show 31, for instance, in this case, no jury's gonna say, what's a bruise, what's that? They're gonna look at it and say, hey, I saw 31 circles on that slope there. That looked like a lot of damage. If it was my roof, I'd definitely want that replaced. And that's gonna be what's persuasive for the jury. So when you present things like weather reports from the very beginning, we get to go in trial and say, hey, we gave you this stuff from day one. We gave you 3 hail reports showing there was hail in the area. We gave you 3 reports showing there was strong winds in the area. And you told us that, nothing happened. Why'd you ignore this? There's 3 of them saying it. So all 3 of these reports are wrong? Or are you wrong? Are you making the wrong decision? But what I think is an underutilized tool right now is that Matterport system. Because like I said before, a jury is never gonna go to the house, right? And we all know with these restoration type cases, a lot of times we have the direct physical loss, let's say in the kitchen, but everything matches throughout the house, right? Well, nothing is more persuasive when we're trying to justify your line items on your Xactimate estimate by walking the jury through each room and saying, hey, this is where you can see that the paint is the same throughout the hallway, throughout the kitchen, throughout the living room, throughout the bathroom, throughout the master bedroom, throughout the 2 other bedrooms. This is where you can see the flooring's the same in the kitchen and the living room. Hey, it changes in the bathroom. Why didn't you add that in your estimate? Well, because it changed. It doesn't match. So we wouldn't need to replace that flooring. Build a little bit of credibility for the Xactimate estimate. So I want you guys, if you guys are dealing with restoration, or if you guys are restoration companies, or if your public adjuster is dealing with those type of losses, I think that's a crucial piece of evidence that I know it's a little bit more pricey up front, but again, right, return on the investment, right? We invest in the beginning, we get the results like we got back there. The insurance company is working together as a team. We have to do the same thing as the consumer side, right? So this is a really long order. The most important part here is paragraph 3, which I blew up on the next page. So what we argued, and Josh found this case because Josh is a case law nerd, and basically this is one of the only cases in the state of Florida that talks about underwriting file, right? And it specifically says that you can get the underwriting file limited to the particular issue of the case. So in this case, they were saying that my client's roof damage was prior to the policy. So I asked for documents evidencing that, including the underwriting file, and they objected and said no. Well, the judge agreed with us and actually discounted their case, which you'll see all the time as attorneys. This is the case that they argue every single time. And that case actually is a general order. It was an order saying it got overturned because the judge said you can have the insurance company's marketing materials, underwriting file, all of these other things that were unnecessary. So your attorneys, for the people that are working with attorneys, you need to make sure that they are making specific requests if there's an argument that there's pre-existing damage, if there's wear and tear, marring or deterioration, which I think is like on 95% of our files, right? It's always wear and tear. I mean, I don't think I've ever seen a file without wear and tear. So if your attorney makes this argument, or if you hire us to make this argument, it should succeed. Because this case law specifically talks about underwriting file related to a particular issue, right? And the particular issue is, did the damage occur prior to the policy? And the judge allowed us to get that document. So bad faith, let's talk a little bit about that. I know you had some questions about it. So as Richie said, there's a big change with bad faith in terms of when we can bring it forward. And we don't have a bad faith case until these two things are met. And then he's like, okay. And then he calls me a couple days later and says, hey, I think that bad faith case is ready. And I'm like, it's not, because we haven't got those two things yet, right? So I want to make sure that we talk a little bit about what we're looking at here. So I made a timeline. And so before that, before December 16th, 2022, so 15, 22, and before, we can rely on a number of cases. And the standard back then was that the bad faith case can be brought without a breach of contract as long as there was a determination of bond liability. So what we were able to do is actually argue that the appraisal award, like we talked about before, was an admission of their liability, right? They originally paid $5,000, or they said it didn't exceed the deductible. Two appraisers got hired, maybe even went to umpire, and they determined that that $2,000 wasn't enough. The insurance company was liable for $150,000, right? And then we also need an expired CRN, okay? So those are the two elements you needed before the law change, okay? And one thing that you guys really should do, especially if you're public adjusters or if you work with public adjusters when you're a roofer or a contractor, if they're going to demand appraisal at any point in time, you need to have the CRN filed before the appraisal demand. It has to be done. They're making a lot of arguments recently, and the bad faith laws are changing every day. We're getting different orders from different courts all over the place. So one of the biggest things is, A, you want to run your 60 days out, right, before that award comes in. So they have 60 days to cure the CRN. You need to run that out before they can actually pay the appraisal award, because no appraisal is getting done in 60 days and paid in 60 days. Okay. The other reason for that is they're making an argument. They haven't been able to produce authority on it yet, but they're trying to convince me that there's authority that you can not file the CRN if it's within 60 days of the demand for appraisal. Okay, so that's one of the things that they're trying to argue. So if you're going to demand appraisal on your side, you need to do the CRN beforehand. It needs to get filed well before the demand for appraisal. So we rely on Fortune versus Protective for that, and then Senate Bill 2A, obviously relying on for the other one. So going back, sorry, to the comments that we were talking about, now what's going to happen, and bad faith was always difficult, right? It wasn't a situation where we were bringing thousands of bad faith claims, because otherwise these insurance companies, we'd have all of their internal practices and procedures because it opens them up to that, right? So bad faith was usually on an appraisal award, because if we're going to take it into litigation, most of the time it's going to settle. They're going to require you to release bad faith. And most of the time we're not getting MSJs because most of our cases are factual issues, right? Was the roof damaged by wind, or was it because of wear and tear? Well, our engineer says it's because of wind. Their engineer says it's wear and tear. That's a factual issue. Judge cannot grant the motion for summary judgment, right? So we were not really seeing bad faith cases outside of appraisal. And it was a very, very smart move for them to use their money to convince the legislature that this should be the standard, right? Because with this being the standard, you need an adverse adjudication by a court that the company breached its contract. So they specifically used the word breach of contract. They didn't use the declaratory judgment like Richie was talking about before in terms of that's something that you can bring. They didn't say upon appraisal award or other finding. They said a breach of contract. So you're either going to have to get an arbitration court to rule that the contract was breached, or you're going to have to get a judge or jury to agree that the contract was breached. After that, and your expired CRN, you can bring the bad faith case. So this really limits the possibility of bad faith before we even get to a damages of bad faith. So that's why it's so important when we're looking at this in terms of how this is going to affect cases going forward. It's really going to depend on those proposal for settlements and our client's ability to want to continue going forward with the case, even though they might have some liability if we don't prevail at trial. Because really it's going to take a jury trial to get us to bad faith. So there's not a lot of clarity if they can retroactively apply this law. I would argue that it's a substantive right, meaning your right to file a bad faith claim is substantive. It's not procedural. It's inherent, your ability to get to court. And as a result, it shouldn't be retroactively applied. But we'll find out what the courts say. All right. So again, just so everybody's clear, because I want to make sure that I kind of hammer this as much as I can. Before the law change, we needed a finding of a liability of the insurance carrier plus an expired CRN. After the law change, we need a breach of contract by a court and an expired CRN.